Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us, who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that, setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation.
Oath or affirmations, announcements by the Vice President.
Honorable Senators, I wish to advise that the President of the Senate, Senator the Honorable Christine Kangaloo, is currently acting as President of the Republic of Trinidad and Tobago. Honorable Senators, leave of absence has been granted to Senator the Honorable Dr. Amory Brown, Senator the Honorable Kazim Hussain, and Senator the Honorable Avinash Singh, all of whom are out of the country. Honorable Senators, I have received the following correspondence from Her Excellency, the Acting President, Christine Kangaloo. By Her Excellency, Christine Kangaloo, Acting President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces, to Mr. Harvey Boris, whereas the President of the Senate has temporarily vacated her office of Senator to act as President of the Republic of Trinidad and Tobago, now therefore, I, Christine Kangaloo, Acting President as aforesaid, acting in accordance with the advice of the Prime Minister, in exercise of the power vested in me by Section 44 of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Harvey Boris, to be temporarily a member of the Senate with effect from the 17th of May 2022 and continuing during the acting appointment of Senator the Honorable Christine Kangaloo as President of the Republic of Trinidad and Tobago. Given under my hand and seal of the President of the Republic of Trinidad and Tobago at the Office of the President, St. Anne's, this 16th day of May, 2022. To Mr. Augustus Thomas, whereas Senator the Honorable Dr. Amory Brown is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago, now therefore, I, Christine Kangaloo, acting President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Prime Minister, do hereby appoint you, Augustus Thomas, to be a member of the Senate temporarily with effect from the 17th of May 2022 and continuing during the absence of Senator the Honorable Dr. Amory Brown from Trinidad and Tobago. Given under my hand and seal of the President of the Republic of Trinidad and Tobago at the office of the President, St. Anne's, this 16th day of May, 2022. To Mr. Michael Seals, whereas Senator the Honorable Kazim Imtiaz Hussain is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago, now therefore, I, Christine Kangulu, acting president as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Prime Minister, do hereby appoint you, Michael Seals, to be a member of the Senate temporarily, with effect from the 17th of May, 2022, and continuing during the absence of Senator the Honorable Kazim Imtiaz Hussain from Trinidad and Tobago. Given under my hand and seal of the President of the Republic of Trinidad and Tobago at the office of the President, St. Anne's, this 16th day of May, 2022. To Ms. Yokaima Bethelmy, whereas Senator the Honorable Avinash Singh is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago, now therefore, I, Christine Kangulu, acting president as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Prime Minister, do hereby appoint you, Yokaima Bethelmy, to be a member of the Senate, to be a member of the Senate temporarily with effect from the 17th of May, 2022, and continuing during the absence of Senator the Honorable Avinash Singh from Trinidad and Tobago. Given under my hand and seal of the President of the Republic of Trinidad and Tobago at the office of the President, St. Anne's, this 16th day of May, 2022. Honorable Senators, Senators are required to take the oath.
Thank you. I, Harvey R. Boris, having been appointed member of the Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, Augustus Thomas, having been appointed a member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, Michael Seals, having been appointed a member of Parliament, do swear by Almighty God that I will bear the true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibility to the people of Trinidad and Tobago upon which I am about to enter.
I, Yokima Bethelmi, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities of the people of Trinidad and Tobago upon which I am about to enter.
The House of Representatives, appearing on the supplemental order paper, the Finance Supplementary Appropriation Financial Year 2022 Bill 2022, in the name of the Minister of Finance.
Acting Leader of Government Business.
Vice President, in accordance with Standing Order 62(1)B, I beg to move that the next stage of the Finance Supplementary Appropriation Financial Year 2022 Bill 2022 be taken on Friday, May 20th, 2022 at 10 a.m.
Honorable Senators, the question is that the next stage of the Finance Supplementary Appropriation Finance Year 2022 Bill 2022 be taken on Friday the 20th at 10 a.m. of the year 2022. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The next stage of the Finance Supplementary Appropriation Financial Year 2022 Bill 2022 will be taken on Friday the 20th of May 2022 at 10 a.m.
Papers.
Acting Leader of Government Business.
Mr. Vice President, I have the honor to lay on the people the following paper as listed on the supplemental order paper in the names of the Minister of Finance and the Minister of National Security. The annual report of the Trinidad and Tobago Securities and Exchange Commission for the financial year ended September 30th, 2020. The annual reports of the operations on the Strategic Services Agency for the years 2019, 2020, and 2021. The annual reports on the operations of the Interception of Communications Act, Chapter 1508, for the years 2018, 2019, 2020, and 21. Thank you.
Urgent questions.
Senator Mark.
Thank you, Mr. Vice President. To the Prime Minister, in light of reports of abuse at the Heliport detention facility in Chagaramas, will the government be taking immediate steps to have 3 children immediately removed from the facility and placed in the care of the Children's Authority?
Minister of National Security.
Thank you very much, Mr. Vice President. I am more than pleased, actively proud and pleased to speak to this House in the stead of the distinguished and honorable Prime Minister of the Republic of Trinidad and Tobago. The question posits that there are reports of abuse. I don't know where the senator got those reports. I have received none. I have seen a newspaper article over the weekend which was fulsome in its treatment on this matter, Mr. President. The Heliport facility is not a detention center. It is an assessment center, and it is used where persons are found approaching and in our jurisdiction or having landed illegally and not presenting themselves at one of our formal and legal ports of entry. Those persons are quite naturally taken into custody. Mr. President, in the COVID experience, all persons, including those approaching illegally as I've just described, are to be quarantined, are to be screened for COVID-19. That facility is designed precisely for that, and as well for them to be assessed by the Immigration Division to assess their landing status. The idea is that they be there for those purposes and to be repatriated as necessary and applicable promptly thereafter. And that is basically what that facility is all about. There are, at this time, about 40 persons there, including children. This question raises the issue of 3 children. And I can tell you, Mr. President, the children are, and the preferred option for those who are there from our experience is that they prefer to be with their children. So the children are allowed to be there with the parents. And Mr. President, that is the state of affairs. Families are kept together in terms of the way we try to do it, husbands and wives, parents and children. Minister, they get the same meals that officers of the Coast Guard share, because the Coast Guard are the ones who provide those meals. There are cameras in that facility, Minister, monitored by persons outside to ensure that there is no...
Minister, your time is up for the answer.
Yeah, Mr. Chairman, Mr. Vice President, I beg your pardon. Can the Minister indicate whether the 3 children in particular who were involved in that incident or accident on the high seas, whether it is the intention of the government to have these children removed from this assessment center and have same placed, that is, children placed in the care of the Children's Authority. Mr. Vice President.
Thank you very much, Mr. Vice President. Action was taken to repatriate certain adults from that facility, and of course, they challenged their deportation orders for repatriation. In the context of that challenge in the court, 3 children loomed large for the attention of the court, and the court suggested that alternative accommodation be made for those 3 children, and arrangements are now being made between the Children's Authority, to whom the court directed that focus, and those responsible for their safe keep at the heliport. Those discussions are underway, and the matter is expected to be resolved. But it only arose because they challenged their deportation orders. And I might tell you very quickly, Mr. President, the parents of those children opted for and signed with the Venezuelan authorities, the mission here, that they want to be repatriated. And strangely, their lawyer came to court and said no, and that created a bit of a discrepancy here. That matter was reported to the Law Association as well, because there was a suspicion that the lawyer was working in contradistinction from his client, or purported client.
Senator Nakid.
Mr. Vice President, given the appalling conditions outlined in the report about the Children's Authority, can the minister state which of those homes would those 3 children be placed in?
I treat that as a very banal and misguided question, Mr. President. I would like to hear with specificity what appalling conditions the senator is talking about before I could answer him.
Senator Nakid, your question, although being supplemental, is being answered by the minister. It's being answered. Yeah? Yes. Yes. Very well. Very well. Okay.
And I described it as banal, Mr. Senator, because in any event, the children are yet to be placed. How could I be speaking about which home at this point? Thank you very much.
Point of order.
Senator Mark, you may move on to question number 2.
Can I ask, Mr. Vice President? Right. To the Minister of Public Utilities, can the minister indicate when will the water supply from the Navet water treatment plant to thousands of residents of the southeastern peninsula of Trinidad be restored?
Leader of Government.
Thank you very much. Mr. Vice President, the supply of pipe-borne water to residents of the southeastern peninsula of Trinidad is provided by the Navet water treatment plant. On Monday, May 16, 2022, an electrical power outage was experienced, as a result of which the pumps at the reservoir were unable to send raw water to the plant for treatment and storage within the clear well. This situation resulted in low clear well levels being experienced at the Navet water treatment plant, resulting in discolored water being transmitted into the system. Following the discovery of this situation, all 17 offtakes along the transmission main from the Navet water treatment plant were immediately closed to contain the discolored water from continuing to enter the distribution system. WASA has advised that as of 8 a.m. this morning, the process of flushing both the transmission and distribution systems were completed. All washout valves along the distribution system for each offtake were also opened, allowing the discolored water that remained in these lines to be drained. Simultaneously, flushing of the clear well at the Navet plant was performed, followed by the flushing of the transmission main. Once the water color was restored, each offtake, starting with those closest to the plant, was systematically opened, allowing clear water to enter the distribution system to flush those lines. Once again, pushing any remnant discolored water out through the still opened washout valves. This process would therefore allow the distribution system to be fully flushed. Several booster stations along this distribution network were restarted, and complete restoration of a supply of clear water is expected by 8 p.m. tonight, with over 75% of the affected customers already having their supply fully restored. The authority apologizes for the inconvenience and thanks the customers for their patience and understanding. Thank you.
The time for urgent questions has passed. We have exceeded it by almost a minute. Thank you, Mr. Mark.
Questions or notice, questions for oral answer.
Acting Leader of Government Business.
Thank you. Mr. Vice President, the government is in a position to answer all questions but question number 146, for which we are asking a deferral.
Honorable Senators, question 146 has been deferred for 2 weeks. Senator Mark.
Thank you, Mr. Vice President. Question number 78 to the Minister of Social Development and Family Services.
Minister of Social Development and Family Services.
Thank you, Mr. Vice President. The Ministry of Social Development and Family Services responded to the Claxton Bay landslide disaster on September the 17, 2021, with a response team comprising officers from the divisions of National Family Services, the Social Welfare Divisions, and the National Social Development Program. This landslide affected 5 families, and the following social protection services were offered: counseling support to all families through the National Family Services Division. Some members of the families accepted the counseling support. The division continues to work with the families to provide the required psychosocial support and guidance. The rental assistance grant was offered to all the families affected. This grant was offered for an initial period of 3 months at a maximum of $2,500 per month. The grant is intended to facilitate the relocation of the affected families. To date, 1 family accepted the offer of the rental assistance grant. The ministry also offered the household items grant to the families which lost these items as a result of the collapse of the home. The ministry was advised that the grant was not required. The Ministry of Social Development continues to liaise with other agencies in an effort to coordinate other options which may become available to the families.
Yeah, Mr. Vice President. Yeah, Mr. Vice President, can I ask the Honorable Minister which other agencies the ministry is liaising with to assist the 5 families that have been displaced as a result of this landslide at Claxton Bay, Mr. Vice President?
Thank you. Minister.
The ministry has been liaising with the Ministry of Housing. As a matter of fact, we held a meeting. I was at that meeting with the Ministry of Housing for an assessment to take place to see how best we can help the families with regards to relocation. But of course, housing is not under the remit of the Ministry of Social Development and Family Services.
Can I ask the Honorable Minister, given the fact that it is almost 9 months since this incident or accident took place, and of course the trauma, psychological and otherwise, that the families have experienced, can the Minister indicate whether the Housing and Urban Development Ministry can, in fact, move with some degree of alacrity to provide some degree of assistance in terms of alternative accommodation for these families who are literally stranded at this time? Can the Minister indicate, Mr. Vice President?
I stated before, housing is not under the remit of the Ministry of Social Development and Family Services. We provided the support that was necessary in all other areas. But of course, we will continue these discussions with the Ministry of Housing. So I can assure you of that.
Is there any other agency of the government outside of the Ministry of Housing and Urban Development that the Ministry of Social Development and Family Services is liaising with a view to providing some assistance to these families that have been rendered in a state of hopelessness at this time?
And the ministry also liaises with EMBD, but I have to get some information on those discussions.
No, Senator Mark, that's to be your 4 questions. Yes. Thank you, Minister. Senator Mark.
Yes, thank you, Mr. Question number 82 to the Minister of Works and Transport.
Minister of Works and Transport.
Vice President. Mr. Vice President, the construction of the Mosquito Creek incorporates 2.4 kilometers of northbound carriageway and includes miscellaneous works, example, revetment, seawall, bridges, and utility relocation, amongst other aspects. Approximately 2 kilometers of the southbound carriageway have been successfully opened to traffic since 2019. Within the ongoing construction zone of the 2.4-kilometer northbound carriageway, a localized 180-meter failure zone occurred. On March 14, 2022, NIDCO geotechnical consultant Earth Investigation Limited commenced geotechnical investigations along the northbound carriageway of the Solomon Holchoy Highway extension to Point 14 at the Mosquito Creek. These investigations include a total of 17 cone penetration tests and 6 standard penetration tests, sample boreholes. EISL completed all 17 CPTs as well as all 6 SPT samples boreholes on April 21st, 2022. The SPT sampling boreholes investigation meant to retrieve undisturbed samples are expected to facilitate the computation of expected total and differential settlements in the short and long term and provide other engineering parameters to support the investigations into the failure. Laboratory test of these samples is still ongoing with a target date of completion of May 25, 2022. Based on the results of the field testing, the consultants will also be performing 4 additional CPT tests. These tests are scheduled for completion by May 20, 2022. The data from these geotechnical studies will be used to develop failure mechanisms and relevant solutions. I thank you.
Yeah. Mr. Vice President, can the Honorable Minister indicate whether his ministry has estimated a time frame for the completion of this particular exercise that he has just outlined, so that that particular area can become usable in the not too distant future? Has the ministry indicated from its research and work when that piece of road will become usable once more?
Senator Mark, based upon the answer given by the minister, which stated dates of the completion of the findings are not available for that, so I won't allow that question.
Mr. Vice President, can the minister indicate thus far what it has cost the taxpayers to conduct these various tests? He talks about 17 CPTs and some 6 SPTs. Can we get an appreciation of the firm that he identified, Mr. Vice President, and the cost accumulated thus far?
Thank you.
Minister.
Mr. Vice President, NITCO would have engaged the firm Earth Investigations Limited, which is under the jurisdiction of NITCO, so I don't have that exact cost. We also engaged the Andean Development Bank, who have provided us with the experts, international experts at no cost. And we also have the team at the Ministry of Works and Transport, the engineers at the Ministry of Works and Transport, also doing their part of the investigation. At this point in time, I do not have a cost for the investigation because the NITCO would have engaged one firm. I think it is headed by Dr. Gee of the University of the West Indies, Dr. Derek Gee.
Then, through you,
Sure.
can I ask the Honorable Minister whether he can make the information of the cost of this project thus far available to us in the Parliament, in the Senate, in writing?
Mr. Vice President, once the process is completed, I'll try my utmost best for that. But at this point, it's an ongoing process. So once the process is completed, I will try to facilitate that request.
President, may I, with your guidance, determine whether the persons who are engaged in these activities, the firm in question, conducting these inquiries and investigations, did the firm, can the minister indicate whether the firm has provided the government with any possible date for the completion of their final investigation? Mr. Vice President.
Senator Mark, based on the first answer, I won't allow that question. Thank you, Minister. Thank you, Minister. Next question.
I have to put it to my colleague again. Can I proceed?
Please proceed.
Thank you. Question number 83 to the Minister of Works and Transport.
Minister.
Mr. Vice President, our system of jurisprudence is based on the tenure of innocent until proven guilty, and the need for parties to act fairly and rationally in the enforcement of contractual rights. In respect to the occurrences at the failure of the Mosquito Creek, therefore, assigning guilt or liability to any party at this time without the necessary evidence to establish same is not a course of action that can be deemed responsible. All contracts in this project, however, have mechanisms for redress and remedy in the event of any party failure to perform out their contractual obligations. Accordingly, if warranted and found necessary, use will be made of any such mechanisms to prevent and protect NIDCO's contractual rights in this matter in the public interest. I thank you.
Senator Mark.
Mr. Vice President, the Minister would agree with me that having expended over $280 million, as I understand it, and I stand to be corrected, on this project, which has now collapsed, can the Minister indicate whether the NIDCO has initiated any inquiry whatsoever into the circumstances surrounding the collapse of this particular piece of roadway at this time, Mr. Vice President?
Senator Mark, based on the answers provided to the previous question, I won't allow.
Can the Minister identify the name of the contractor involved in this project?
Minister.
Sure. Mr. Chairman, just to correct and to put on the record before I name the contractor, the information of the government already expending $280 million is false. The entire package was $280 million, most of which have been completed. There's a failure on 180 meters of the highway. So it is not that the government would have spent $280 million and the highway would have collapsed. That is a false premise. The contractor on that site is one of our local contractors, one of the largest, more experienced contractors in Trinidad and Tobago. I think it's Jusamco Beavers.
Yes. Can the Minister indicate the possible costs that will accrue to taxpayers, given the additional work that would have to be entertained by NIDCO through this contractor? Would the Minister not agree with me, Mr. Vice President, that the taxpayers will be called upon to bear additional costs that we did not anticipate? Can the Minister clarify for us?
Senator Mark, based on the answers of the previous question, as it applies to the ongoing testing, I will not allow that question. You have one more question.
I thank you, Mr. Vice President.
Thank you, Minister. Senator Sipasad.
Thank you, Mr. Vice President. Question number 145 to the Minister of Finance.
Minister in the Ministry of Finance.
Good afternoon, Mr. Vice President. As part of the routine operations of the National Insurance Board of Trinidad and Tobago, or NIBTT, all employers are provided with appropriate national insurance education, including at the point of registration as an employer and through the NIBTT's robust and ongoing educational campaign. The educational thrust is focused in most part on benefit awareness and employer compliance requirements. Various educational brochures are also available to employers on different aspects of the NIS. In addition, employers can access the customer care call center at the NIBTT's website to receive further information and guidance on the NIS. Should employers require special training, they can directly submit a request through a compliance officer at or by emailing their request to seminars@nibtt.net or customercare@nibtt.net.
Mr. Vice President, through you. Minister, the fact that we have non-compliant employers, will the government consider introducing measures, which could be legislative as well as other measures, to deal with these delinquent employers to make them compliant with the NIS requirements?
Minister?
Yes, there are already systems in place, and we will continue to try to capture as many delinquent employers as possible.
Maybe there's some other things that could be done that because there's still such a large number of delinquent, non-compliant employers. It is affecting the funding of the NIS fund.
Number, how many would that be?
You need to phrase that in a question.
Oh. Yeah. Minister, given the fact that the measures do not seem to be as effective as they should be, what other measures will be introduced to bolster the contributions not being paid by delinquent employers?
Vice President, I accept that there may be some delinquent persons out there, but I could not say that the measures currently in place are ineffective.
Would you like to move on to the next question? You may.
Question 147 to the
One
Minister.
moment. Yeah. Would you allow Mr. Mark to give way for a supplemental? Sure.
Mr. Vice President, through you to the Honorable Minister. Honorable Minister, could you inform this Senate whether the NIB has done an estimation of the possible potential value that the NIB would have lost and continues to lose as a result of delinquent employers not complying with the NIB rules as it relates to their submission of their monthly contributions on behalf of their employees? Is there some kind of estimation of revenue foregone by the NIB as a result of this particular situation? Mr. Vice President, thank you.
Yes. Minister? Mr. Vice President, I would not have that information on hand at the moment. What I can say is that the NIB is always thoroughly looking for those who are, of course, violating their rules.
Question 146, Senator C. Prasad.
Question 147 to the Minister of Finance.
Minister of Finance.
Mr. Vice President, under the National Insurance First Schedule Amendment Order 2018, the present government effected a change in 2018 to increase the overseas investment limit from 20% to 30%. This decision has so far paid significant dividends and has contributed to the impressive 14% return on investment earned by the NIB in 2021. A number of other proposals to amend the first schedule of the Act, including expanding the number of jurisdictions in which overseas investments are permitted, is currently before the Ministry of Finance for consideration. The Ministry is also giving careful consideration to a further increase in the NIB's overseas investment limit, but a decision on this matter has not yet been made because of the current volatility of the international capital markets.
Vice President, could the Minister indicate when he thinks some decisions are going to be made? Because even if there's always volatility. It's how you mitigate those risks that you need to be taken into account.
Mr. Vice President, current capital markets, international capital markets have been exceptionally volatile. And we would have to wait for those markets to calm before we decide on exactly how we're going to treat investments in the international arena.
You okay? Thank you, Minister.
Public business, government business, bills, second reading.
Honorable Senators, the debate on the second reading of the following bill, which was in progress when the Senate adjourned on Tuesday, May 10th, 2022, will be resumed. A bill entitled, An Act to Provide for the Regulatory Control of the Handling of Cannabis for Certain Purposes, the establishment of the Trinidad and Tobago Cannabis Licensing Authority, and connected matters. We have had, thus far, 11 speakers who've contributed, including the move of the motion, the Attorney General, and we would resume debate. Senator Thompson, aye.
Thank you, Mr. President, for affording me the opportunity to speak on this bill, Cannabis Bill 2020. I had passed by UWI Student Guild office that day to greet the then Administrative Assistant, Valerie Belgrave, a most beautiful soul. When she introduced me as the new law students representative to Brother Resistance, as he then was. He and his sidekick, Kwame, promptly invited me to a meeting later that day at which they urged me to sign a statement to the effect that we students rejected capitalism, fascism, communism, socialism, and a heap of other isms I had never heard of before, and which never found a place in Pat Bishop's history lectures or Claire Fiffy Broadridge history class at Holy Name. After that initial encounter, whenever I passed outside the eye room and detected a strange odor, I would glare at Brother Resistance and his brothers and ask, "What I smell in there? I hope it's not weed, you know." Resistance would give me a toothy grin, and Kwame would have that sly smile on his face. I would give them a cut eye and walk away. Today, had Lutalo Masimba and Kwame not been deceased, knowing my abhorrence for weed smoking, they would have surely died from shock to hear me speak anything remotely in favor of a cannabis bill. At the very least, Masimba would have put on his dancing shoes and said, "Is what? Hazel was care damn for we culture? Ring the bell, ring the bell." Rest in peace, brother. It's almost a year since we lost you. This Cannabis Control Bill 2020 has as its long title, An Act to Provide for the Regulatory Control of the Handling of Cannabis for Certain Purposes. the establishment of the Trinidad and Tobago Cannabis Licensing Authority, and connecting matters. It is a progression from the Dangerous Drugs Amendment Act 2019, which inter alia defined the words cannabis, smoke, public places, and decriminalized the growing and possession of specified amounts of cannabis for personal use in private spaces. Today, we continue the debate on regulatory control and the licensing authority. The earlier bill had 9 clauses. The present one has 67. Some bodies went to town on this bill, including a joint select committee. Let's see if they got it right. Now, I must say that there is a sizable cross-section of the older members of the community who are not at all pleased with decriminalization of marijuana, weed, as Jamaican might say, ganja. They have seen many young persons' future destroyed and fear the harm it can cause to our nation's children. Are those fears warranted? In an article, Feeling Good, The Curious Woman's Guide to Cannabis, published in the April 2019 edition of Oprah magazine, Jacoby Zoldan wrote, and I quote, "You can smoke it, vape it, sip it, or spritz it. You can bake it into brownies. You can find it in lotions and potions to rub on your skin, tinctures to drop under your tongue, capsules to swallow, or oils that have been added to your latte or ice cream." 2 Saturdays ago, I was walking through Lisbon Airport trying to find a place where I could get the antigen, which was required for me to enter Madrid and then Miami and Piaco airports, when I came upon a booth marked the vaping shop. I immediately went in that direction and was given a crash course in the different types of cannabis products, the number of milligrams required for them to be safe, etc., etc. The young man was quite an expert. My husband was impatiently reminding me of my mission until I explained it was research for the Parliament debate. "You were always on duty," he sighed. The author Zoldan stated that the use of marijuana was linked to an increased risk of schizophrenia in those with genetic vulnerability, and the risk went up the more you use. She also quoted a 2018 study which found that 1 in 10 frequent marijuana smokers who gave up their habit experienced cannabis withdrawal symptoms, which could include symptoms such as feelings of anger, irritability, or aggressiveness, abdominal pain, fever, chills, sweating, headache, or tremors or shakiness. And those of us who have been around young people would be familiar with these symptoms. HealthyChildren.org, a periodical of the American Academy of Pediatrics, in an article by Claire McCarthy, MD, FAAP, titled "Legalizing Marijuana, Not Good for Kids," stated, "Marijuana use is remarkably common among youth in the U.S. According to the most recent surveys, about 1 in 5 high school students has used it in the past month. Even more concerning, 1 in 12 has used it at least 20 times in the past month, and 1 in 6 uses it daily. I do not know of a comparable study for this jurisdiction, but I would love to know if such a study exists. The AAP believes youth should not use marijuana. There is a popular perception, the AAP says, that marijuana is not dangerous, but it is dangerous both in the short term and the long term. And here's why they say. It interferes with judgment, concentration, reaction time, and coordination in ways that can make the youth more likely to get into car accidents or otherwise injure themselves while using it. The way that it interferes with brain function, such as memory, attention, and problem solving, can make it much harder for youth to learn in school. Contrary to what many people think, it can be addictive. Inhaling the smoke can cause lung problems. New research shows that marijuana use during adolescence and young adulthood, when the brain is going through many important changes, can lead to permanent problems with memory, learning, and thinking. Another caveat against marijuana use is that youth who use marijuana regularly are less likely to finish high school. And I'm sure we know a number of dropouts because of marijuana. That's why it's important that laws prevent youth from buying marijuana. Even more, we need to do everything possible to prevent them from using it or being exposed to it. Now, in light of this expert opinion from American Academy of Pediatrics, some must wonder, why are we in Trinidad and Tobago looking at regulating control of handling of cannabis instead of making bonfires and burning all the weed we could find, or giving our soldiers cutlasses and having them earn their keep, as I saw them doing in Kentucky in the United States in 1972, slashing fields of marijuana growing of all places alongside a public highway. I could not believe my eyes. The bill before us today answers to some extent these burning questions. Now, let me look first at the interpretation or definition section, specifically Clause 3.2, which gives the definition of actual or contingent pecuniary interest. And this is something that keeps cropping up throughout this bill, this phrase. It's an important concept in the legislation because if you have an actual or contingency interest, which are big words to mean really a conflict or potential conflict of interest, certain consequences arise. It states, for the purposes of this act, a member who or whose nominee or relative is, as the case may be, a shareholder who owns shares in excess of 5% in, or B, a partner in, or C, an employee of a company, firm, or other entity regulated by the authority shall be treated as having an actual or contingent pecuniary interest in that company, firm, or other entity. Rather convoluted. It's not really meant for the layman. That's for lawyers to make more money to interpret. Relative. The question of who is a relative is therefore important in the context of actual or contingent interest in a company, firm, or entity regulated by the Trinidad and Tobago Cannabis Licensing Authority. Clause 6.3 states, no person appointed to the board shall be or become engaged or employed in the handling of cannabis or have an actual, again, or contingent pecuniary interest in any company, firm, or other entity. Clause 8E provides for revocation of the appointment of a member if the member is or becomes engaged or employed in the handling of cannabis or acquires, again, an actual or contingent pecuniary interest in any company, firm, or other entity which is regulated by the authority. Clause 14 of the bill requires every member to, within 1 month after his appointment and on each anniversary of his appointment, submit to the minister a declaration in the approved form stating whether or not he, A, is engaged or employed in the handling of cannabis, or B, again, has an actual or contingent pecuniary interest in any company, firm, or other entity which is regulated by the authority. I'd like somebody to whisper in my ear after, who just came up with this phrase. But in the bill, relative is given a narrow definition. We think we know what relative is, but when we read this bill, what do we see? Relative is defined as spouse, cohabitant within the meaning of the Cohabitational Relationship Act, father, mother, brother, sister, son, or daughter of a person. So that's what relative means in this law. But that is not the ordinary meaning of the word. The dictionary defines relative differently. It states a relative is a person who is part of your family. Parents, siblings, uncles, aunts, grandparents, cousins, nieces, and nephews. They are all relatives, aren't they? Now, when the definition speaks of cohabitant under the cited law, that's the Cohabitational Relationship Act, it exempts from the purview of the authority someone who can qualify to be a common law spouse. It may be a common law union of less than 5 years or fewer. Mr. President, some men in our society change common law wives as often as, I better not say that, but they change them often. So if someone lives as a board member for a shorter period of time, that person would pass through the holes in the net and escape detection, as he or she would not fit into this law's definition of relative. The definition also omits a very important relative in this society, cousin. A cousin may be even closer to you than a sibling. I had such a cousin with whom I was very close in my earliest years. She was closer in age to me than my siblings, and we were very, from since childhood. We were like sisters. Just like my mother, she was very good in a seamstress, and she could, while I could only make apron and curtain. And she would say, Hazel, when you're getting married, I'm making your dress. She was not able to do so, but flew in from Canada, bringing my wedding dress and accessories. When I learned she was dying from lupus, I dropped everything and went to McGill University Hospital and spent 10 days at her bedside. Today would have been her birthday. We say cousins make dozens, as some cousins are too close. They're like the royal family. I advise we review our definition of relative, or we might have to ask board members to write all your family name on a piece of paper for we. I am not saying all of we is one family, but I'm saying the definition of relative is too restricted. Long ago, we regarded Guyanese and Bajan as smart men. Now it's Trinis leading the pack, so we have to plug all the holes. Most other legislation simply require you to disclose the conflict of interest and do not go the route of identifying relatives who may pose a threat to the law's expectation that your integrity requires you to operate at arm's length when dealing with transactions in your official capacity. Most times, simplicity is the best. As Confucius says, life is really simple, but we insist on making it complicated. Clause 4 curiously states that the functions of the authority are to advise the ministry on the development of national policies and measures for the regulatory control of the handling of cannabis. Now, generally, legislation speaks of advising the minister. Clause 5.4 reads, the minister may give the authority in writing such general policy directions as appear to the minister to be necessary in the public interest, and the authority shall give effect to those directions in the performance of his functions. The minister is usually defined in the law as the minister to whom responsibility is assigned for the particular matter under consideration. When you look at Section 15.3 of the Legal Aid and Advice Act, it states that the authority may, with the approval of the minister and subject to negative resolution of Parliament, make regulations for the purpose of administering any program. When you look at the Children's Authority Act, you see in Section 5 that the authority may advise the minister on matters relating to the operation of this act. I would wish to be advised as to the reason for the departure from this practice. At best, it seems an awkward way of proceeding. Clause 5 deals with the functions of the authority. I will not repeat them. A number of members who went before did. I suggest, though, that we add two provisions. The first is to develop enforcement procedures in relation to inspection of premises that are operated by licensees in order to ensure compliance with the provisions of this act. You see, Mr. President, we are very good with plans and ideas, formulating new laws, but when it comes to enforcement, we have problems. Indeed, we keep hearing in this Parliament about our implementation deficit, which we keep wearing like a badge of honor. Another provision I would wish to see in the law is a requirement for research by a duly accredited tertiary institution or other approved body. I am borrowing, I am not borrowing because I'm not giving back. I am taking this from Jamaica's Dangerous Drugs Amendment Act 2015. A similar provision appears in the St. Vincent and the Grenadines Medical Cannabis Industry Act 2018. Section 5.2 provides for the authority to facilitate scientific research in respect of medical cannabis and, where applicable, apply the results of such research in the development of the medicinal cannabis industry. So let us spell out in the Act who must conduct the research. Mr. President, we still do not know all we can about cannabis. Research is ongoing in several countries. The AAP that I mentioned before believe that if marijuana is to be used as a medicine, it must be done carefully and with research to understand all of its effects. This body stated that there was more need for research on the use and safety of marijuana in youth. While studies have shown the chemicals in marijuana do seem to help people with chronic pain as well as nausea, vomiting, and appetite problems that are common in cancer, the studies were all done on adults. Youth are different from adults and may react differently to marijuana. We need to find ways to fund this research and make it easier to do so that we can really understand about how marijuana affects our youth. Our first responsibility, and I'm quoting here from the AP document, in everything we do as parents and caregivers should be our children, because they rely on us to keep them safe and well, and because they are our future. Marijuana policies are no different. Let's be careful, thoughtful, and keep our children in mind. The AAPP cautioned against adults using marijuana around children. It advocated banning of any marijuana to youths, making sure that there is child-safe packaging and creating public health campaigns similar to the ones used against smoking. Clause 6 speaks to the composition of the board of directors. I'm happy to see the inclusion on the 9-member board of a person with qualifications and at least 5 years' experience in drug rehabilitation. I hope we can find such a person. Many are called, but few are chosen. We are talking real qualifications here, not reputation. I trust that the appointments by the President would be in her sole discretion and not on the advice of the Prime Minister and Leader of the Opposition. Clause 6.6 states that the President shall determine the remuneration of members, and Clause 6.7 states that the remuneration of members shall be reviewed by the Salaries Review Commission. So why put this duty on the President in the first place? I think she has enough to do already, and the Commission is better placed, as it can determine from their institutional knowledge and experience of these matters a quantum which is reasonable. Clause 10 provides for immunity of members from personal liability for anything done or omitted in the discharge or purported discharge of the functions of the authority, unless it is shown that the act or omission was a result of gross negligence or done in bad faith. Now, some members have expressed dissatisfaction with the wording of this clause, and I myself confess that I have some reservations, and I propose instead that the wording be changed to that of Section 29 of St. Vincent Medicinal Cannabis Industry Act 2018, which is identical to Section 13.1 of Jamaica Dangerous Drugs Amendment Act 2015, both of which state no action, suit, prosecution, or other proceedings shall be brought or instituted personally against any member of the board or employee or agent of the authority in respect of any act bona fide in pursuance or execution or intended execution of this act. That way, we do not have to spend precious time trying to determine if a particular action was gross or de minimis, which is legalese for minor. But we will consider whether the action was done in an honest or sincere way. Clause 16, I particularly like, as it empowers the board to employ such persons as it considers necessary for the due and efficient performance of its functions under the Act. I would encourage the board to cast its net far and wide, as there is out there some people with a much-needed expertise who can make a difference to our failing in our purpose and getting it right in the way that could be so beneficial to our populace. Clause 21C provides for payment out of the Trinidad and Tobago Cannabis Licensing Authority fund established in Clause 20, the remuneration, allowances, and gratuities, I repeat that, and gratuities payable or to be made to the Chief Executive Officer and to employees of and persons engaged on contract by the authority. I am particularly pleased by this. I have come to Parliament time and again to complain about the hardship being suffered, in particular by contract employees, including those formerly employed by the Children's Authority to get their gratuities, over 100 of them waiting, some for over a year for their money. It is disgraceful and smacks of a lack of empathy for our fellow citizens. As I said earlier, there is a view that this cannabis bill is not in the interest of right-thinking members of society. Some ask, can anything good come out of this Nazarene bill? Why is cannabis being removed from the war on drugs? Why are so many countries taking the route of regulating the cannabis industry? Let me begin by detailing some of the much-touted benefits of marijuana from the same Oprah magazine article I quoted earlier. 1, better sleep. That's a suggestion. I can do it some. There is moderate evidence it can help you snooze, but experts are not certain that the effects won't wear off with regular use. 2, improve gastrointestinal issues. Although it did have some effect on cells taken from people with inflammatory bowel disease, it is not certain, though, of its effectiveness on the patients themselves. 3, mitigates anxiety. Tetrahydrocannabinol, or THC, which is one of the many chemical compounds in the cannabis plant, produces a euphoric feeling and alters sensory perception. Because a lot of the time you see the marijuana, people are just smiling, they're happy. And CBD, which is non-intoxicating but may be potent in other ways, appears to ease anxiety at all doses that have been tested. Clearer, smoother skin, free of pimple and eczema, was another plus of cannabis, referred to by Krista Bennett de Mayo in the July 2019 magazine I spoke of earlier. She spoke of research which showed that it is because it can calm inflammation, which is why it was often used to manage chronic pain like arthritis, as it plays a key role in acne and eczema flare-ups. So because of these seeming benefits, some countries have decided on legalizing the use of cannabis for medicinal purposes. Before one gets into the business of medical cannabis at the various stages of the process, certain licenses must be obtained. Clause 29 of the bill thus makes provision for licensing for medicinal, therapeutic, or scientific purposes. So we are looking at, first of all, medicinal purposes. The authority can issue various types of licenses, such as cultivator license, a research and development license, a laboratory license, a processor license, a retail distributor license, an import license, an export license, and a transport license. Clause 41 to 45, though, sets out certain requirements and safeguards for the use of medicinal cannabis, and these seem adequate. Mr. President, what can be gleaned from these applications for license provision is that therein lies tremendous opportunities for a new trust towards entrepreneurship. But the question is, where is the capital to come from? And also, who will provide the much required training opportunities, and who will be the beneficiaries? Those greedy volunteers who already have too much, or the disadvantaged who have only hope? It is a challenge for the government to put their money where their mouth is, to have courage in the face of campaign financing obligations, which sometimes get in the way. Mr. President, in the Caribbean region, we have true Rastafarians. And then we have the fashionistas. Last night, I had the pleasure of speaking to one of the former. He follows all the tenets of the Rastafarian faith. He eats no meat. He attends no funerals, even of his closest relatives. In fact, when his British mother died, I went to the funeral, and he was there, and some people were there around him consoling him, because he said he couldn't go. He comes from an upper middle-class family, but he knows what it is to be arrested by the police for the sacrificial herb. I have often heard his story from various lawyers about his being dressed up by his fellow law student to go to court in Barbados. With fear in his heart, he remembered being represented by Elliot Motley. He said Sobian provided the tie, Mabota provided the coat, Ken Saga gave him a haircut, and he went to court transformed. In that case, he was proven, he was deemed innocent and was acquitted. And he swore to me up that I spoke to him just before I came from my home, and he said, yes, that is true, I was not guilty. I shared with him that he could register an NGO and apply for a license for his organization because cannabis is required for religious purposes as a sacrament in adherence to a religious practice of the Rastafari faith. I warned him, though, that there were certain safeguards under clauses 46 to 49 which govern the use of cannabis for religious purposes. And he did share with me that he and another well, a lawyer now, just demitted office as a minister, and some other people had actually set up a company, but they're waiting on their jurisdiction to pass the legislation, which govern the use of cannabis for religious purposes. An article dated 20th November titled Cannabis Legalization in Uruguay, should be 2018, Public Health and Safety Over Profit, stated that Uruguay was the first country in the world to introduce a nationwide regulated retail market for the production and supply of cannabis for non-medical use. The government's plans were motivated by concerns over insecurity and public safety and aimed at reducing criminality and violence by depriving organized groups of control of the cannabis market. They wanted the market strictly regulated with very limited commercial involvement, and a number of jurisdictions are looking at it that way. What they're saying is that if we have regulations in, then we wouldn't have all of these underground things happening, and we can actually do something for the people who generally suffer because they are doing illegal acts. So what Uruguay did is that they organized it so that just 2 companies would produce the cannabis to sell through licensed pharmacy to registered over 18 Uruguay residents. All promotion was banned, so you couldn't promote it. The rationale was that a legal cannabis market will reclaim most of the trade from organized crime groups, and this would subsequently reduce rates of violence. Because as we know, a lot of the violence we have in our society revolves around this trade in drugs. Who wants which turf? Who protects what turf? You know, so they keep fighting against one another. And a lot of the murders are happening because of that. But what is happening there is that the retail prices were set below the current illicit market rates. There was an anonymized national registry of cannabis users to track purchasing patterns to moderate the use and minimize the risk that legal cannabis will be diverted for sale on the illegal market. However, their well-thought-out plans have not given the desired result. Even in Canada, it was reported that inadequate measures to promote market access for small producers resulted in a select group of large federally licensed corporates set to dominate the market for years to come. Mike Adams, in his article, Reasons Marijuana Legalization Seems to be Failing, written in November 5, 2019, stated that the black market pot trade is way stronger than the legal sector, and nearly 43% of the country's pot users continue to buy weed from illegal sources. Cannabis firms are laying off workers in Canada and in the United States. It is in our interest to research the reasons for the failure of a dream gone wrong. What will happen in our country? We wait to see. Will regulation benefit the citizens of this country? It is a concern that has been expressed here by more than one speaker. How can we ensure that our regulation of the industry does not result in those who have more corn feeding more fowls? How to ensure that those who suffered because they have been used by drug lords to take all the risk and very little of the profits finally get their just share? We array the regulations and hope that our legitimate concerns, that it would be the same old, would be unfounded, and the government will get it right. I note that the regulations are subject to affirmative resolution. And you know, we don't normally go that route, so that is a hopeful sign. So we will await to affirm. Will this be a success story or a dream deferred? I hope the former. Thank you, Mr. President.
Senator John? Sure. Senator Welch, would you like to come? Senator Welch, your mask while you make your way to the booth, please.
Mr. Vice President, thank you for the opportunity to address this honorable chamber on the bill which is presently before us, which deals with the establishment of the Trinidad and Tobago Cannabis Licensing Authority. I was not part of this chamber, was not privileged when legislation decriminalizing the use of cannabis was introduced. I was not so privileged. And that process started with the Dangerous Drugs Amendment Act, the effect of which, in brief, was that it decriminalized the use in small quantities for recreational purposes, so that persons were even able to cultivate a limited amount of trees for their personal use and to use it in private circumstances. I regard that, Mr. Vice President, as indeed a legislative masterpiece, so to speak, because the consequences were an unburdening of the judicial system, which was clogged with numerous cases relating to possession of small amounts of marijuana. It also resulted in the removal of the stigma which was attached to someone who was convicted for such an offense, in that it affected a number of young persons' careers, in that it is something which showed up on their criminal record. And in that regard, that legislation was indeed commendable. Mr. Vice President, when one looks at this new bill which is before us for debate, one at first blush might be forgiven for thinking that this is merely an extension of the permissibility into the realm of medicinal purposes, religious purposes, as well as therapeutic purposes. At first blush, this is the impression that is created. And the reason I say so is because when one looks at the title of the bill, it says, it begins, an act to provide for the regulatory control of the handling of cannabis for certain purposes. And then when one looks at the licensing provisions, for instance, Part 4, 29.1, it says, the authority may issue any of the following licenses for medicinal, therapeutic, or scientific purposes. You may have such licenses. There's no mention of anything which amounts to a commercial license there, for instance. And I fully support this bill insofar as this is the interpretation which appears from its provisions. These three categories which have been identified. And the reason for that is, it is only fair if recreational use is allowed. It is only fair that legalization for medicinal purposes be allowed, because it is well documented that there are certain medical benefits, which I do not propose to question at this stage, but I respect the documentation, I respect the documentaries I've seen, I respect the benefits alluded to by some of the contributors here already. I also support it because it speaks to therapeutic, which also relates to medical, such as the relief of pain, the suggestion that it reduces the intensity of seizures, persons suffering from seizures, and such matters. I also support it when it speaks to religious purposes. Again, because that is an exercise I regard as the one's constitutional right to freedom of religion and expression. And if as part of that freedom of religion and expression, it can genuinely be demonstrated that the use of cannabis in that regard is a genuine, sincere, bona fide use by such religious groups, it is only fair that this bill extend to such uses. And the reason why it is important in that regard is because such uses, as identified in this bill, medicinal, etc., and religious, may not be accommodated under the legalization process which took place with the Dangerous Drugs Amendment Act for recreational purposes. For the simple reason that persons who need it for medical purposes may need it in larger quantities than is allowed for by that act. Similarly, religious adherents who wish to use it for religious purposes may need it in quantities larger and in circumstances at a public event which is sponsored by a religious organization in larger quantities than what is permitted by the Dangerous Drugs Amendment Act. So if we have recreational use, I think it is a natural step to extend the permissibility to such areas. However, the reason why I say at first blush it appears that this is what this bill is about is for the reasons which I've already identified, how the clauses are phrased. My concern, however, is that when I listened carefully to the contributions, especially of the government side with respect to this bill, it is obvious that this, as some of the contributors have put it, this is really regarded as a form of economic diversification, a form of boosting of the economy, a form of driving employment upwards, a form of export and the possibility of foreign exchange, increasing through export. So my first criticism of the bill is that on its face, there appears to be a certain amount of conceptual uncertainty. It says one thing in its title, it says one thing what the licenses are for, but when you listen to the contributions and when you look at some of the detailed provisions regarding licenses, it is really about economics to a large extent. It's not just restricted to those purposes. It's like the creation of an industry somewhat masquerading behind a facade of medicinal and religious purposes. And that is my difficulty. In that regard, the bill is conceptually uncertain at best, and at worst, potentially misleading. Having identified what government policy in this bill is, which is that it is not restricted to those beneficial purposes I've identified under the three categories, but it's regarded in this as an economic drive, so to speak, and the creation of an industry. I would now want to look at some of the points which have been made with respect to that. But before we go to that, Mr. Vice President, my concern is if for any industry to succeed, for any business to succeed, for any economic measure to succeed, while I am not an economist, I think I know enough to state that it must be driven by demand. There must be a demand, there must be a consumer demand, and there must be an extensive consumer demand for it to succeed. And if we are talking about success as an industry and extensive consumer demand, then we are talking about the implication of that is necessarily a far more widespread use, increasing the level of demand by those stakeholders who are investing in this licensing process. If we are increasing the level of demand, and that's the only way it can succeed, then my concern is about the possible social ill effects and impact, because that exists as a matter of fact. It is documented that the use of marijuana, it's nice politically correct term, cannabis, it is addictive. It is documented that in some instances, it can actually potentially do harm. I am familiar with what Senator Ahi spoke about with respect to analysis that has been done, which speaks to how it affects one's attentiveness and that sort of thing. and reduces alertness, etc. But quite apart from that, it can also do potential damage in some instances. I recall the leader of government business alluding to the fact that there an example of which he knows of someone who has used cannabis and ended up in the psychiatric hospital. But he pointed out that there are many others who have used it for a number of years without that effect. I too know of an example, which I don't rely on hearsay for, of a young individual who tried it and ended up with mental problems for the rest of his life. And I said, I don't rely on hearsay for that because I asked the persons associated with him, I asked his parents, and I asked different people who were in the know. And I was informed it was a situation where he was a person who had never smoked a cigarette before, who had never used marijuana before, who had never been exposed to alcohol in any large quantities. And on the block a day, he decided to try it for the first time, and he was offered, and that was the end of that. The high he got, he never came down from it. So in the same way that the leader of government business has spoken of an example, this is also an example on the other side, and which, to me, is an indication that there are persons whose minds and brain, which has never been exposed and which is fertile and unvarnished, the introduction of this drug to such a person can have such a potential effect. And my concern is how many times this can be multiplied. If this as an industry gets out of hand in the way it seems to me that it must do if it is to generate the type of economic activity which has been spoken of. So there has to be a serious balance and a serious judgment call as to what is more important, potential economic benefit or potential ill effects. Because once this is established as an industry with several licenses and everyone involved with looking to make a profit out of it, they have to market it. It will fail as an industry unless there is demand. And when demand increases, it spreads unwittingly beyond the present use, which is allowed by the Dangerous Drugs Amendment Act, which is recreational use in small quantities. And Mr. Vice President, I also ask myself, the reason for my lack of excitement as well over this commercialization, this economy-driven exercise, this motive of what it can do for employment, etc., is, again, I say I am not an economist, but I ask myself, when one is talking about economic measures and making a radical change to the status quo, it would seem to me that feasibility or feasibility study is all part of that process. And in that regard, I have heard, I've heard from contributors that Jamaica has done it. St. Vincent has done it. Antigua has done it. What I have not heard is exactly what has been the result economically or socially of those initiatives, those legislative initiatives in those jurisdictions which have been identified. How has it increased? How has it increased employment? What is the percentage? How has it driven GDP up? How has it earned foreign exchange? What levels have been attributable to it? What are the statistics demonstrating success as a result of this legislative measure in such countries? To me, that is all part of a feasibility exercise. What I have heard simply is that they have done it, and it is time for us to get on the bandwagon. It seems to me that that is not feasibility. That is follow fashionism. Mr. Vice President, it has been spoken of as well in respect of its potential. I've heard one of the contributors make mention of its potential for export as well. But again, using my amateur economist approach, I ask myself, where is the potential for the foreign exchange, so to speak? Because for one, you can only export to countries which allows for importation. You can only export to countries or jurisdictions which have a legislative regime which has legalized the use of marijuana. And if one looks at it from that possibility, many countries are wiped off the market because not all that many have moved towards legalization as yet, even if it is contemplated. So those countries cannot be part of the projected market for export. And if what is left are the countries where it is legalized already, then they are producing their own. So why would one think there is a market for our product which is now coming, so to speak, on stream? And coming at this stage, why would one think there should be anything so special or unique about it or its quality coming from here that will make it an attractive product to anyone else? But under the licensing provisions, they also allow for the import licenses to be granted. And we know very well that, and it is something which I have commented on in previous contributions, we tend to have a taste for foreign products. So we have to be conscious as to, when we speak of export, we have to be conscious about the import licenses which may be granted and which can be a potential drain on foreign exchange if the foreign product is found to be more advanced, more well-processed, and better. Well, I do not want to say taste because I'm not a user myself, so perhaps gives a better high, so to speak. Another aspect of it which has been advanced is the question of a lot of persons becoming potentially employed in this industry, cultivating, transport, etc. But I ask myself, when I look at the legislative regime and the provisions and what is involved, whether there is any incentive for persons at the smaller level to get involved. Because this is a bureaucratic monster, so to speak. First of all, you have to apply for a license. You have to give all your details, even though it is said that the small man, anyone over 18 can apply. Give all your personal details. A license, you're not sure to get the license. If the license is obtained, you have to pay a prescribed fee, which presumably would be a fee of some significance. It wouldn't be trifling. Then you have to naturally subject yourself to whatever restrictions in terms of quantity the license would be given for. Perhaps limited quantities. One has to subject oneself to that. Then one has to consider the license is only for 3 years. And there is no guarantee of renewal. So if it's for 3 years and no guarantee of renewal, the smaller individual may want to contemplate, is there incentive for me to go into this? And further to that, there is also the situation of the inspectorate, where you have to subject yourself to the possibility of not just regular policing, but the inspector regime. The point I'm making about this is not that these things are not necessary, not that they are not important, but what is the incentive, since it has been said that everyone is getting a piece of the pie, the smaller man, the medium person, the larger person. What is the incentive for someone operating at a smaller scale to go into such a venture when there is so many administrative steps and inconveniences? There is a lack of ease of doing business insofar as a small potential farmer is concerned. And this may very well result in a lack of interest in this process. And if it results in a lack of interest in this process, then having paid a considerable fee, etc., then it also means that there would not be participation in it. There might be far more an inclination to continue doing what I'm doing, selling at the block or selling wherever. There is something called, again, I'm not a professional economist, but there's something called the economies of scale, which concept dictates that if, in order to make a profit, in order to make a successful economic go at something, it would require you to at least engage in that economic activity at a much higher level before you can meet your costs. And in that regard, it may well be that even though that is not the intention, it may well be de facto that this is only a reasonable prospect for someone operating at a larger scale, at a larger business, and it may only be attractive to such companies at that wider scale. And that defeats the argument which has been advanced that it is open to everyone. Technically and legally, It is open to everyone. But not everyone is going to find this administrative machinery, monstrous machinery, to be worth the time and the effort to get into, bearing in mind the restrictions which may be placed upon you in terms of how much you can sell, where you can sell, where you are confined to, and the inconvenience of renewal and paying the fee again and subjecting yourself to the parallel police that is emerging under this bill called marijuana inspectorate coming down on you. And according to the provisions of the bill, they can come down on you with or without the police. That is why I refer to it as a parallel system of policing which one would have to subject oneself to. Mr. Vice President, there are also quite a number of issues. Given that this bill is what it is, I have just looked at it from a macro, larger policy point of view perspective. But there are also some issues with some of these provisions which I think need to be tightened up. Given that it is government's policy to introduce this, then there are provisions which certainly need some tightening, and which I would seek to perhaps address during the committee stage, deal with the micro aspect of it during the committee stage. In terms of feasibility, one also has to ask oneself as to balance what we hope to achieve against what is necessary to create, to achieve it. And this is why Senator Vera's point on this issue struck a chord with me. What is this we are creating? Is it necessary to indulge in this? I say it's necessary for the three purposes which have been identified at the start of my contribution. But limiting oneself to these three purposes cannot justify this machinery that is being created, and one has to ask oneself, because when you look at it, you are talking about a board, 9 members of that board, a licensing regime, quite a number of staff to be hired, the right to, according to this, the right to acquire property, the right to borrow using government as a collateral, therefore contributing to debt as well. And also, more significant than anything else, the fact that it is to be funded on the consolidated fund as well. Because the prescribed fees for licenses, you certainly cannot hope to run a machinery of this magnitude based on the prescribed fees that may be charged for licenses and fees, etc. So it is a potential drain on the consolidated fund, and one has to bear in mind what is one getting for it and what is the justification for it. Is it possible, in other words, to perhaps create something which is necessary for that limited purpose, where we can identify genuine cases of medicinal use, therapeutic use, and religious purposes? Or has this gone out of hand simply because the underlying motive is economy and it's being regarded as an industry? And as I've pointed out, that underlying motive has to be balanced against social impact, because the adage is relevant. Sometimes it is said, money is not everything. And my own adjustment of that, money can sometimes make the world go wrong. W-R-O-N-G. There's also another one about money being the root of everyone knows what. So we have to balance it. I certainly hope that this is not the elusive diversification that administration after administration has been speaking about. Because when one listens to the contribution about it is an economy thing, it is an export thing, and I'm using words that have been used in the contribution. It is an industry thing. At one moment I wonder if this was the elusive diversification.
Senator Welch, you have 5 more minutes.
Thank you. However, having regard to what I have said before, there are some measures which I consider to be important and necessary, and which I commend because it takes care of some of my concerns. For instance, this machinery that is being created, there is an obligation on it at the end of every year to report on its expenses, revenues, and its activities. There is a clause which provides that it has to be reported to the minister. So there is a level of accountability. And that level of accountability is justified because one has to see tangibly what one is getting out of this creation. What the legislation lacks, however, is what are the consequences of a failure to comply with the need to report on expenses and incomes that are earned and the activities of the authority. And that, to me, is also important. It's not good enough to say there is an obligation to do so without any kind of consequence for failing to comply with that obligation. And I say this is important because far too often, one hears of Auditor General's reports or of statutory authorities which have not filed their required statements or reports for any number of years. And then 8 years down the line, you might hear of some kind of corruption that has been taking place, who has benefited from the revenues collected, etc. If another such authority is going to be created, let the lesson be learned from those authorities which exist now and which have existed in the past and which have not complied, and which, as it turned out, there may have been corruption and ill-gotten gains involved. We know too well that anything which involves licenses, from recent experience, anything which involves licenses and the issuance of licenses has the potential to lead to corruption. So if an authority of this nature is being established, let it not only report, but be under an obligation to do so with some kind of consequence. Put in a radical measure. Otherwise, it may not be legislatively diplomatic how I put it, but that is for the drafters to work on. Hinge it to the renewal or the continuation of a contract for those who are responsible for doing the reporting, so that we will not have the creation of another dysfunctional institution which there are going to be accusations about its processes and its legitimacy and whether it has been functioning with propriety. So let there be some legislative provisions in that regard. Mr. Vice President, I have the macro level matters which I spoke of and which I think can contribute to the improvement of the provisions of this bill and which I have not addressed during this contribution, because of course there is also the committee stage. But I have issues with certain things. I think the caregiver provisions definitely need to be tightened up.
Senator, your time has elapsed.
Thank you very much, Mr. Vice President.
Senator Timor.
Thank you, Mr. Vice President, for the opportunity to contribute to the bill before us. Mr. Vice President, if I may, before I begin my contribution, I'd like to express my serious concern about the desecration of the Karapu Temple in Arima. In my opinion, this was no attempted robbery, but it was a deliberate act aimed at denigrating and shaking the spirit of the Hindu community. And in my view, this act borders on terrorism and has no place in our plural nation. And it is my hope that the perpetrators of this despicable act be swiftly caught and brought to justice. Mr. Vice President, Senator De Freitas, in his contribution to this debate, introduced a rather interesting dimension by his intimation of a generational gap among senators. He seemed to infer that the young senators appear to have no problem supporting this bill, whereas the older senators seem to be allowing the stigma of cannabis use to influence their position. Now, I do note that Senator De Freitas was very careful in excluding the Honorable Attorney General from this age-based classification. I would like to let the Honorable Senator know that I have been involved in social and cultural activism for decades on a voluntary basis, and I have had the opportunity and good fortune to work with mainly young persons during this time. And I would also like to let him know that there are times when the exuberance of youth has to be balanced by the wisdom and experience that comes with age. Particularly in unprecedented circumstances, when it's always better, when you are in new territory, to proceed on the side of caution. The reservations about the bill expressed by the so referred to age senators would have not been on stigma and prejudice, but by the hard reality of seeing the damage done to persons and families by the abuse of cannabis and the consequential addiction that goes with it. The resulting negative impacts on the health and well-being of individuals and the disastrous adverse effects addiction can have on the family unit and the community. The forerunner piece of legislation to this bill, an act to amend the Dangerous Drugs Act, Act number 24 of 2019, effectively allowed for the use of cannabis for personal or recreational use through decriminalization. And this bill before us sort of completes the package in that it will allow for the religious and medicinal use of cannabis in Trinidad and Tobago through regulatory control by a Trinidad and Tobago Cannabis Licensing Authority. Now, one of the major reasons put forward to justify the decriminalization of cannabis, and one that I agree with, was one of social justice, where we saw our boys and young men of socially disadvantaged communities no longer running the risk of making a jail for small possession of marijuana, and also deriving the benefit of having their criminal records expunged and also be allowed to reintegrate into communities and the wider society. Good. The other major reason was that there would be a reduction of the burden placed on the criminal justice system by the overwhelming number of cases for possession of small amounts of marijuana that had clogged up the remand yards and courts. And the bill before us today, Mr. Vice President, is based on the reasoning that there are commercial and medicinal benefits to be derived from cannabis, as well as it would allow for the rights of citizens who utilize it in their religious practices. This is unprecedented legislation, since our knowledge of the harm caused by cannabis use is incomplete, and interpretations of the evidence are often contested. So is also our understanding of the medical and other benefits of cannabis use. It's still evolving. The research is still evolving, and the conclusions are still far from complete. And the lack of good epidemiological and clinical data has made it difficult to assess conclusively the adverse effects and also the benefits of cannabis use to the users and the public. In my opinion, this bill limits the avenues for minimizing and managing the adverse effects of cannabis use, which is the public health aspects, and it maximizes the benefits of cannabis use, as it is based primarily on the commercialization of cannabis and the development of a cannabis industry. Mr. Vice President, there is enough research to indicate that the decriminalization and legalization of cannabis signals to adolescents and non-users that cannabis is now socially acceptable. The American Society of Addiction Medicine, in their public policy statement on cannabis, concluded that cannabis use disorder in cannabis users is not rare and can be serious. And we have heard from several of the speakers before about addiction. And cannabis use has been shown to be associated with cognitive decline, impaired educational or occupational attainment, risk of other substance use disorders, and poor quality of life. It has always been shown to be associated with impaired driving, fatal vehicle crashes, cannabis-related emergency room visits, psychosis, and psychiatric comorbidity. Cannabis use disorder has also been associated with disability and strongly and consistently associated with other substance abuse and mental disorders. We cannot also discount that the adverse effects of cannabis legalization can be socially inequitable, although we have heard that one of the intentions of this legislation is to bring about equity. For we have heard from several speakers about inherent disadvantages to the small man. And there is no doubt that legislation will reduce social inequalities arising from unequal enforcement of criminal penalties for cannabis possession and use. However, addicted cannabis users, like problem gamblers, are more prevalent in the more socially disadvantaged communities. The legislation of cheaper and more potent forms of cannabis products may increase the number of regular cannabis users in poorer communities to the economic detriment of users and their community. There is no doubt that evidence-informed substance use prevention and treatment interventions can avert or delay the initiation of cannabis use by the vulnerable. It can stop progression from use to harmful use or addiction, and it can reduce cannabis use-related negative health, social, and economic impacts. Other jurisdictions have identified several risks and protective factors predictive of substance abuse that are amenable to prevention interventions, and they have developed evidence-informed resources for educators and clinicians to help prevent particularly adolescent cannabis use. Mr. Vice President, the reason that I focused my contribution thus far on the public health issues that can arise from this legislation is that the bill seemed to be mainly crafted on a framework for the commercial development of the cannabis industry. And I agree totally with Senator Welch in his contribution that this commercial interests would seek to increase demand because of the economic equation for a return on the investment, and what are the possible social consequences of such marketing. by these commercial interests. I would have much preferred to see a more broad-based strategic approach that includes public health and social evaluation of the impacts of this cannabis legislation. Now, Senator Lakshmi Dayal did speak about rehabilitation in her contribution, and Senator Richards also spoke about abuse and addiction, whilst drawing parallels with that of the alcohol and tobacco industry. The Honorable Senator Sagram Singh, in her contribution, indicated that there are provisions for a person with qualifications in drug rehabilitation to be on the board. The Honorable Senator indicated that such a person would ensure that the policy and measures for drug rehabilitation are considered by the board, and in her opinion, that further legislation for drug rehabilitation may not be necessary at this time. The Honorable Senator also indicated that in her opinion, such legislation could come after some years when the cannabis industry has developed more. I respectfully submit that I do not agree with the Honorable Senator here. For in my opinion, a strategic approach to cannabis legislation warrants a concurrent approach in ensuring that public health issues are also sufficiently addressed in the legislation. Just having someone on the board with drug rehabilitation qualifications, in my view, is not good enough to guarantee that policy and measures would be put in place. The strategic direction of the board in this regard has to be clearly spelled out, and legislation needs to identify prevention and interventions and rehabilitation as a specific function of the board, such that it gets the resources it needs. We must legislate this aspect to ensure that adequate funding and resources are allocated to address the need. Some speakers from the government bench also spoke of addiction only in the context of medicinal cannabis and likened it to addiction to other prescribed medications. I'm not speaking about addiction and rehabilitation in this context, but in the context of personal recreation and soon to be legalized religious use. We need to be mindful that this is not only about rehabilitation, but it is about identifying and protecting the vulnerable, discouraging use of cannabis for the vulnerable, and ensuring that prevention measures are identified and implemented. As I mentioned before, this is unprecedented legislation, and I'm of the view that there is enough evidence, enough research-based evidence on cannabis use disorder to legislate now for dissuasion and prevention of use by the vulnerable, and also treatment of cannabis use disorders. Mr. Vice President, NADAP, the National Alcohol and Drug Abuse Prevention Program that falls under the Ministry of Social Development, is charged with the responsibility of coordinating drug abuse prevention and demand reduction initiatives in Trinidad and Tobago. And I would have liked to hear from the government that as part of their strategic approach for cannabis legislation, that they would be looking at expanding and sufficiently resourcing NADAP to include for the prevention and treatment of cannabis use disorders. In light of all what I have said so far, when we look at the functions of the authority stated in Clause 5, we see no specific function regarding identification and protection of the vulnerable, discouraging the use of cannabis for the vulnerable, and ensuring prevention and rehabilitation measures for cannabis use disorders. Now, this omission to me begs the following questions. Who would take up the responsibility for stakeholder engagement regularly to collect, to analyze, and to publish health data for planning and implementing public health and social programs? Who would take up the responsibility to make policy and program recommendations by collecting and analyzing data to support prevention and rehabilitation efforts? Who would take up the responsibility to implement new development programs and more data-driven efforts to make sure behavioral and mental health needs of our adolescents and transitional age youth are met, and that persons are trained and equipped with best practices for dealing with cannabis use disorders and cannabis misuse? I am proposing that a specific subclause be added to the functions of the authority as listed in Clause 5 of the bill to meet the answers to these three questions. Mr. Vice President, Clause 5.3b states that in the performance of its function, the authority shall facilitate scientific research in respect of cannabis and development of the cannabis industry. Again, we see a heavy emphasis on the commercial aspect of this bill, and there is no specific mention of research needed to inform policy, measures, and development of programs for, again, identification and protection of the vulnerable, discouraging use of cannabis for the vulnerable, prevention and treatment of cannabis use disorders, and addressing the social and public health impacts of cannabis use on the population. This research is necessary. Clause 6.2 provides for various disciplines to be represented on the board. In my view, again, there appears to be a skew towards the commercial side of this bill, and I'm proposing that the disciplines of social development and public health be added to bring about a much-needed balance to the board. Clause 41.1 authorizes a medical practitioner to prescribe or recommend medical cannabis. In Clause 3, interpretation, a medical practitioner has the meaning assigned to it by Section 2 of the Medical Board Act. Now, Clause 10A of the Medical Act deals with registration as a medical specialist, but this is not here in the interpretation for the medical practitioner, and it is one of the requirements. One of the requirements for a medical specialist is training, experience, and qualifications in the area of specialization. I ask the question, is medical cannabis an area of specialization? And should the medical practitioner be called upon to have training and experience in the field of cannabis medicine? Or would there be compulsory training on medical cannabis for medical practitioners prior to them being allowed to prescribe or recommend cannabis products to patients? Mr. President, I'd like to go to, Mr. Vice President, sorry, I'd like to go to Part 6 of the bill, which deals with cannabis for religious use. And this is even more unprecedented legislation. Who determines what is religious use, since it is not defined in Clause 3, interpretation? What interpretation of religious use would be used by the authority in granting of the licenses under this section of the bill? Would it be left to the courts to decide what constitutes religious use for the purposes of this legislation? If a license is denied by the authority and legal action is taken by the aggrieved. Clause 46.1 prohibits the controller of a religious organization which is permitted to handle cannabis under a license from any type of commercial benefit or engage in any type of sale, supply, or other transaction for any money or for any profit, financial or monetary gain or compensation. However, we see clause 29, 3D, allowing for an export religious license, which allows for the export of cannabis to any country in keeping with the laws of any such country. I think there seems to be a contradiction here, as I cannot think of any circumstances where one would want to export cannabis outside of a commercial arrangement. Why would a religious organization want to export cannabis if not for commercial reasons? Unless it's a donation that they are giving to other countries. So why should we be allowing an export religious license for religious bodies? If it is religious bodies, that license is based on non-commercial use. Clause 47B states that the sacramental dispensaries can only dispense for persons registered as adherents to the religious organization. And I ask the question, would the licensing authority monitor this register? And what sort of database and controls would be set up to ensure that adherents are not registering with several other religious organizations to beat the system? So we may have one person registered with maybe 4 or 5 different organizations to collect that, to be beneficiaries of the dispensing, just so that they can beat the system. And in such a case, what would be the fines? Would any fine be imposed on an adherent caught practicing such deception? Clause 47C states that no more than 30 grams of cannabis shall be dispensed to any single adherent. However, no limits on the frequency of dispensation are defined. So we have an amount to be dispensed, but the frequency of the dispensation is not addressed in the legislation. Is it daily? Is it weekly? Is it monthly? We don't know. And although Clause 49 prohibits dispensing to children, no specific regulatory measures are stated to control dispensing to children. Clause 48.1, Mr. Vice President, appears to be rather liberal in that it states that the minister may by order declare an event to be an exempt event for the purposes of this act. If he is satisfied with, and there are certain conditions stated here, promoted or sponsored by a person who is an adherent of a religious organization, and B, primarily for religious purposes, in accordance with the provisions of this act. Clause 48.2 on exemption goes on to state that no person at an exempted event shall be liable for arrest, detention, or prosecution for any offense, or any other penalty regarding cannabis, be it transported to, which is possessed, supplied, or used at the exempt event, in such amount and under conditions as specified in the order. Mr. Vice President, this exemption raises several questions and concerns. One, does such an event violate the non-commercial aspect of religious use? Would these exempt events be commercial-oriented? And in such a case, would it violate the non-commercial aspect of religious use? Would such exempt events be allowed in public spaces? What is the legislative and regulatory role here for the authority? None is stated in the legislation for exempt events. The promoter or sponsor of the event is not the religious organization or its controller, as previously stated for the licensing, but an adherent, even though one of the conditions for event exemption is for primarily religious purposes. So we have an exempt event in which the promoter is not the controller or the religious organization, but an adherent. Why stretch it like that? The license requirements under this Act for cultivation, transport, and religious use and dispensation are voided once the amounts and conditions stated in the order are not violated. The question is asked, where would the cannabis be coming from for these exempt events? Would it be from legal sources? And who would be transporting it? Would special temporary licenses have to be issued by the authority in this case to the promoter or sponsor to facilitate these exemptions? What is the special arrangement and what is the role of the authority regarding licensing for these exempt events? The legislation is not specific on it. It is just subject to the minister issuing an order. And with all the aspects of legalization under Clause 47, sacramental dispensaries apply here. Would individual order users be allowed no more than 30 grams at exempt events? And how is this going to be monitored and enforced at an exempt event? Would only religious adherents be allowed at the exempt event? And how will this be enforced? Or would the exempt be open to the public, the exempt event? Would the promoter or sponsor be required to have inspectors from the authority on duty at the event to ensure compliance with the amounts and the stated conditions? Clause 49.1 suggests that children would be allowed at exempt events. Should we limit exempt events to be strictly for only adults 18 years and over? If not, and children are allowed at exempt events, would the authority be asked to stipulate the regulatory measures and enforcement controls to ensure that cannabis is not dispensed at these exempt events to children? Whilst we tout the benefits of cannabis, I shudder to think of the trauma that parents would have to undergo when they discover that their children are attending these exempt events and the accessibility to cannabis is increased due to a lack of any specific licenses, lack of regulatory control, and enforcement at these events. I'm not sure how much of what I've raised would be dealt with in the regulations, but this is the reality of having to pass legislation without the benefit of draft regulations, or even a draft framework for the regulations. I can't help but propose the deletion of Clause 48 from this bill. In my view, it is too broad, and it allows for too many loopholes for abuse and circumvention. I'm of the view that it can be brought as an amendment 2 years after the proclamation of this bill, which would allow time for development of the relevant evidence-based research to properly legislate for exempt events, including a clear definition of what this event could be. It is not in the regulation, it is not in the legislation what this event could be. I don't know, is it a cannabis social? What could the event be termed? And special licensing and regulatory policy that would be required to facilitate such events. Mr. Vice President, I thank you.
Senator John.
Thank you, Mr. Vice President, for the opportunity. Good come after many speakers, and we've had some very solid presentations. Mr. Vice President, as has been said before, this, the Cannabis Control Bill really seeks to provide for the regulatory control of the handling of cannabis for certain purposes. And it goes on to say these purposes would be for religious and medicinal activities, I believe in the first instance, as outlined in this bill. And the legislation also establishes the Trinidad and Tobago Cannabis Authority with responsibility for the regulatory control of handling cannabis. Mr. Vice President, I looked at Hansard and I was particularly interested in the presentation of Dr. Dial Singh, because many doctors, you'll find, they really like drugs that are peer-reviewed and have stood rigorous tests and clinical studies, etc. And from what in quoting him, he said he has reached a stage now in his life thinking, should I give somebody Xanax, or should we go to a natural thing that can help anxiety? And Mr. Vice President, these questions are being asked because I believe this is still an emerging industry. And basically, several speakers will have really pointed to the establishment of this Trinidad and Tobago Cannabis Licensing Authority, which is quite an expensive undertaking. And without the benefit of the research which could project and tell us there's no real empirical evidence which indicates that this will have somebody come of success. And one might say, but nothing ventured, nothing gained. But certainly, again, I want to add my voice to that, that basically in looking at this bill, you are not seeing where the government would have done any rigorous research really for what it is, medicinal purposes and for religious purposes. And basically, we have not seen, we don't know how many, if there's a projection as to how many religious undertakings will be interested, or even who are the small farmers who are now interested, or any farmers at all, or growers of the cannabis, because I'm sure there are many who are now doing this on an informal scale, whether there'll be any uptake in this whole licensing regime, if indeed this is how the authority intends to kind of fund some of its costs. Mr. Vice President, again, there is no doubt that there is some relief to be gained from the use of this cannabis, but I'm asking, will there be a differentiation of products? You know, because there are many different things that range from oil to cannabis flowers, etc. Maybe it's too early to ask, or I don't know if the government knows whether they are going to have any kind of downstream, how they are going to have brand extension or whatever it is, or if it is just within this confines of medical where they are going to license folks to dispense the drugs, whether medical practitioners or pharmacies, and then, of course, religious entities, and some serious questions that really need to be responded to, or at least there should be a lot of thought into what will constitute or what will be defined a religious entity. Now, Minister Dial Singh spoke about a three-pronged approach to retrain pharmacists like himself, and basically there'll be an ongoing education. But he did not say the same, because in his own contribution, he said, as I come to a close, when he was wrapping up, he said, just to reiterate, that the issue of medical marijuana is one which is engaging all stakeholders to train practitioners, whether doctors and what have you. But we are here debating this bill. Subsequent to its passage, the government, I believe, will proceed in establishing this authority at great cost to taxpayers, but the engagement, I'm not getting the sense that there's been any engagement, given the two train that they're running on with respect to the doctors and pharmacists and so on. And I can tell you that doctors in many cases, and that is why I listen to Dr. Dial Singh, they could grow up, when they're growing up, they have a fever, give them free fever grass. As medical practitioners, they are not going to drink that fever grass because there's no science. Well, with all due respect, you're a dentist yourself, Honorable Vice President, because of the lack of science with the fever grass, etc., they know it's good, it would have done something when they were young, but as an adult trained professional, it's hardly likely that they will go out and pick that fever grass lying in the yard. Mr. Vice President, the Minister of Health also pointed to about 40,000 persons in Trinidad and Tobago living with seizure disorder. However, he took, I think, a responsible approach when he said, however, the 40,000 persons, they really are not all candidates to be treated by this cannabis for its therapeutic effects. So I'm asking, so how many, if we are not sure, because this has to be the pool that one is projecting onto. And if it is, we don't have 40, the probability is somewhere within 0 and 40,000, sorry. What then is the number we are looking at? And again, I heard some very serious questions relative to where will the demand come from? Is this cannabis for export, the export market, or will one then kind of have an engagement where cannabis will become cool in Trinidad and Tobago so that more people will be encouraged to smoke cannabis or use cannabis and whatever is derived from that plant. So I think this is very serious. Senator Welch would have spoken about that, about the demand, and I think he's right, because the Senate has been asked to really approve this expensive admin infrastructure, and we are not sure how they are going to, is this going to be another state organization which will be reliant on the taxpayer and the exchequer. In addition to, mention was made to the ease of doing business, because we have this very rigid licensing regime. So I guess the government is trying to balance the danger of the cannabis, as they see, because there's a dark side to it, against the potential for some level of economic activity and return on person's investment. And basically, I believe that this is not well thought out in terms of this regime of license, because people who are there in their area, wherever, having their plots, maybe planting peacefully, I don't know. I don't know what is the motivation for them to come and engage themselves in bringing themselves from the darkness into the light, where the light would add a lot of cost to their to the how they do their business, a lot of cost to their business model, because it means the price of their product is going to go up, even within the context of this whole regime of licensing and oversight, which I suppose is necessary. But notwithstanding that, one have to now look at how will that add to the cost of this product, as it were, Mr. Vice President. And one will ask if the Attorney General can indicate if the regulations will specifically really say to us who can prescribe this cannabis-based medicine in Trinidad and Tobago, because in the UK, through the National Health Service, you cannot get cannabis-based medicine from a general practitioner. It can only be prescribed by a specialist. So one wants to know what will be the safeguards. It will only be prescribed by a specialist, hospital, doctor, but that means you first have to go to a GP, and then you end up at the specialist to get this this prescription. So it means that a lot of cost will be added. This person who perhaps is now getting this cannabis without all of the quote-unquote rigmarole, they are getting it, and maybe they're already using it for, not for pleasure, but for medicinal purpose. One has to look at, will they be encouraged to come out from that informal sector and get into the formal sector based on the additional cost and the additional restrictions. Mr. Vice President, as an additional barrier, medical cannabis is considered something of a last resort, and that is in the UK. Doctors should they're first encouraged to consider prescribing medicines that are licensed for the specific medicines, for the specific conditions, that the patients present with. That is because these products have to be tested for safety, quality, and that's what I'm talking about, the rigid testing of clinical studies for medicine, because at the end of the day, it's human beings who have to take these things. So we are moving from testing into actual application on human beings, and many things can go wrong. So that is because the traditional path that we have known, products have been tested for quality, safety, and efficacy by the regulators for the indication that they are prescribed for and are subject to the quality assurance arrangement that apply to all licensed medicine when they are manufactured. So, you know, I think we still have a way to go with this, Mr. Vice President, because for those who are inclined to use cannabis for medicinal purposes in Trinidad and Tobago at this time, there are no middlemen. However, in the new dispensation, as I said before, a patient or user will first have to secure a prescription from a licensed doctor. If this is not correct, I am hoping that the Honorable Attorney General will clear that up. And basically, even if a patient can afford a private consultation and prescription, there are still a number of barriers to entry. Because in order to be eligible to be prescribed for this medical cannabis, a patient will need to have a qualifying condition. I am told in some jurisdictions, persons will need to have tried 2 previous licensed medication. So I don't know if we'll have all of these barriers to entry because we don't have the regulations in front of us. So, which in many cases can be debilitating drugs such as opioids or antidepressant. So, Mr. Vice President, so for many people, a private medical prescription just isn't a viable option many times due to the ongoing costs, the escalating costs. For many patients, this decision may be a simple one, but for others may choose to buy it illegally, to choose to treat their medical condition or suffer while remaining on the right side of the law, because the price of seeing a consultant is quite prohibitive for many people. Right, Mr. Vice President? So basically, there's another issue I want to raise very quickly with respect to it was in the Appendix 2 of the Joint Select Committee report, and it concerns a summary of key issues, roundtable discussions with cannabis authorities from the CARICOM region. And I can't recall hearing this issue raised as yet, but I just want to ask, how will Trinidad and Tobago address the corresponding banking issues treated within the global financial sector, given that cannabis is still considered illegal? You know, and a lot of people are still grappling with it. It looked like something that one could do, but I suppose Minister Diyal Singh had cautioned and said it's not a silver bullet. So we have another issue in terms of banking issues, because one of the major issues recently highlighted by CARICOM Chairman Gaston Brown was that corresponding banks in the U.S. have indicated definitively to the corresponding banks here within the region that in order for them to maintain their corresponding bank relations, they couldn't accept cannabis deposits. And this is a serious thing that you cannot, even in Jamaica back in 2020, the Ministry of Industry, Commerce, Agriculture and Fisheries had to engage international stakeholders as many major banks are reluctant to fund the growth of medical cannabis out of fear. So even if they would have gone, fill out the form, gone through all the prescribed criteria, and end up being designated a legitimate business in a trader in this commodity. If you want to grow, chances are you may find yourself not being able to raise money from the banks. I don't know if the government of Trinidad and Tobago is going to do something different. So basically, I ask the question, what has been done with the banking sector to ensure problems such as these are avoided? Because as you're aware, Mr. Vice President, this country has been grappling with blacklisting for the last 5 years. So I'm hoping the minister will tell us what safeguard he has delivered or he has in mind to ensure that our banking sector is none the worse should this legislation become operational. So, Mr. Vice President, with those few words, I want to thank you for the opportunity.
Thank you, Senator. Thank you, Senator John. We would have a short recess and meet back here at 5 p.m. sharp. Suspension.